is now in session.
Please be seated. This is the time scheduled for oral argument in our case, State of Arizona versus Sussex, 1 CACV 130009. Both sides have been allocated 20 minutes for oral argument. If the appellant desire to reserve any time for rebuttal, feel free to, you can do so. But there's a clock on the podium, and recognize the clock, the time remaining includes your rebuttal time, so you have to manage your own time. To assist you, you should be aware that we have read the briefs, we have looked at pertinent portions of the record and the cases and statutes, and have conferenced this case. So we're relatively familiar with the law and the facts. Despite the fact that you have 20 minutes per side, that's not an obligation that you use all of it. If you're done with your argument, we don't have any further questions, you should just sit down. Also be aware that we are audio and video recording this argument. So be ready for your close-up. And when you get to the podium, please clearly state who you are and who you're representing. With that, counsel for the appellants.
I would like to reserve 5 minutes for my rebuttal. Your Honors, my name is John Willenchek, and I represent the appellants in this case. We are asking the court today to protect the home that my client's family has been living in for over 120 years from being taken away by the government. The Sussex family bought their home in 1892 and has lived there ever since, as before the state of Arizona was even a state. To paraphrase Malcolm X, the Sussex family did not settle intentionally on Arizona state public land. The state of Arizona settled on them.
Counsel?
Yes, sir.
Can I direct your, there's a burning question in my mind.
Please, Your Honor.
There's basically a quiet title action,
Correct.
and there's a trespass action.
Correct.
Nowhere in your briefs do you say the court's judgment on the trespass action was erroneous.
That's
So
correct.
if we, to the extent that you're challenging the quiet title action, why isn't that moot? Because there's no argument in your opening brief that says the court erred in granting a trespass and injunctive relief thereon.
Your Honor, our argument is that if the court is incorrect in granting quiet title, then the following ruling on trespass and injunctive relief is incorrect, erroneous, and moot.
Where is that in your opening brief? Where do you say the trial court erred in granting a trespass, an injunction on trespass, in the final judgment? Because they were wrong, the court was wrong on the quiet title.
I know that was briefed in the reply brief in response to the counter appeal regarding issues on the trespass. As to whether we specifically assert in the opening brief that the later decision on trespass would be moot and irrelevant, I don't know that that is briefed in the opening brief.
How did you or your clients acquire an interest in 1894 with respect to at least federal land? Because that's the issue, that the federal government had the land and eventually returned it back to the state. So how did you acquire, other than being there, a possessory interest from the federal government?
It's a very good question, Your Honor. Our argument following the Freightways case is that when there is an extreme case of laches, it's not necessary that the original claim to title have been valid. As the Freightways case stated, however much time is required before a void claim becomes a valid claim was not something the court decided as a matter of law, but left it rather to each individual case to determine. What the Supreme Court said in Freightways is that where there's a delay of at least 50 years by the state in asserting its claims, then the court had no hesitancy in saying that that was sufficient time for a void claim to turn into a valid claim. In other words,
How is that responsive to Judge Portley's question, that at least through the 1860s, perhaps through about 1945, with a brief deviation or detour to the SRP project, the property was owned by the federal government?
correct. We admit that, and we're not even arguing that, nor do we have to argue that the Sussexes had a valid claim during that time. The federal government did have a valid claim during that time.
Okay. And they transferred their claim to the state.
That's correct.
So how did they then somehow acquire, because at least as I understand it, that there was a lease back in the 30s that the state canceled for non-payment.
That's correct, Your Honor.
So at least that raises the issue that maybe the state really hasn't sat on its hands so much as, really not forcing the issue sooner, but clearly knowing that they had their interest and were going to protect it periodically.
Correct. The issue that we are arguing is that there's a material issue of fact as to whether the state was on sufficient notice that the Sussexes were present on the property and claiming title, and that as a result of a unreasonable delay of at least 50 to 100 years in pursuing its claim to quiet title and trespass, the defendants have been prejudiced because they're no longer able to dispute those claims, also because they have been living on the property for so long under the impression that they owned it, that they've been personally prejudiced by the delay in time. So to answer your question, Judge Portley, it may well be that the Sussexes did not have a valid claim to title during that entire time period. Our argument instead is that a void claim has ripened into a valid one.
And when did that happen? When is the point of ripening?
As the Supreme Court said in Freightways, that something has to be looked at a case-by-case basis. But here I think the lower court should have no hesitancy in saying that a delay of over 50 years, just like the Supreme Court said in Freightways, is sufficient to hold the state to account for its laches.
But Freightways is the state giveth, and the state then try to taketh away.
Correct.
And laches is going to apply. What case do you have that says the state didn't giveth, but when it tries to assert its right, it better do it, that Freightways would apply to apply laches to it?
There is no case in the Arizona jurisdiction, but there are cases in other jurisdictions. We specifically cited a case in Illinois, People v. Weitzman, in which the court there found that the state was stopped by laches after a delay of 50 years. And we are also arguing under some older case law. Again, there's a case in South Carolina entitled Crocker v. Collins, in which the court also held that laches, the state can be stopped in laches.
And those involved situations where the state didn't giveth and then try to taketh away?
That's correct, Your Honor.
From a practical standpoint, the concern I have about laches is this. According to the record, in 1930, a great-grandmother of Mr. Sussex filed an application for a lease. And then in 34, the state canceled that for non-payment. So basically, you don't have a right to be there. You haven't paid your rent. Then in 38, the state leases the property to a Van Horn, and during at least around 1951, a Sussex ancestor filed for a home site lease, and the state rejected her application. So now we have a second event where the state says, no, you don't get to come on here. And then we have the issues that happened in 1956 involving the improvements, and the state eventually settles, and a Sussex ancestor compromises a claim to improvements and doesn't want to pursue that, thus again suggesting we don't have a right to be there, or there's at least some issues. Then you have the issues in 98 and 2005 and so forth. So it's hard for me to see where the state has been. Maybe the state has been a little slow, but every so often there's movement and action by the state vis-a-vis your clients and your client's family, basically saying, it's our property, it's not yours. So I'm having a hard time just looking when I look at the proverbial ball of wax as a whole, seeing where there's latches.
It's a fair question, and I think my first response is that, as Your Honor mentioned, there are issues, and this is an appeal of a granting of motion for summary judgment. So as much as there are factual issues there, we would like the ability to raise them to a jury. One of the issues, as you mentioned, is that the state sent a letter addressed to the property and addressed to their family at the property, again indicating that it was aware that they were present. Aside from that, there's also factual issues about whether or not that certificate of lease back in the 30s was a certificate of purchase. Again, factual disputes about what the record even is, given there's been a good 100 years here now of the record. And again, our argument would be that due to that delay by the state in bringing suit, there's been a loss in our ability to present a case, there's been a loss of evidence, and death of witnesses.
What do you do with the 1956? Here's your check. I accept the check and I agree not to appeal the order that's going to go ahead and try to sell the property.
The importance of that letter is that it was addressed to the family at this address, and therefore the state had knowledge that they were living at this address.
But she accepted the check and agreed not to. I mean, that's uncontested, right? She got a check. One of the ancestors got a check for the improvements, and with in a proceeding that was going to then go ahead and sell the property, and she decided not to seek any review of that order going to sell the property.
It's contested whether or not. I think the second half of that is contested. The first half, that she received a check compensating for improvements, is uncontested because.
But where's the contest on that she didn't? There by accepting it, she wasn't going to appeal from the order allowing the sale.
The fact that that statement is not contained in the letter, and also the fact that she's dead and unable to testify.
Well, but we have a record where there's no, at least there's no indication that there was ever a lawsuit filed in order to contest it within a reasonable period of time.
By the state as well. That would be my argument.
Okay.
Okay. And there's at least an issue of fact there as to whether the state had that burden to then pursue a lawsuit.
Why would the state have a burden to pursue something in which they had paid money to your client's family to avoid a fight over improvements so that they can proceed or ratify, I can't remember now whether the sale had already occurred, but anyway, so that the sale can in fact be legitimized? How is that the state's burden? They've just paid their way out of a problem.
Again, there's a dispute of fact as to whether that letter has exact characterization that you described. We contest whether that letter was a settlement of any kind of issues with the sale of the property. We contest that our clients are even aware this property is being sold, again, based on the fact that we're dealing with people who have been dead for many, many years.
But on summary judgment is not good enough to say we contest. You have to come up with some type of controverting facts.
Correct. Our controverting fact is that this letter was addressed to their family at the property, and therefore the state was on notice that they were living there and occupying the property since at least that time. And therefore there's we've raised enough of a dispute fact to show laches, which is that the state waited an unreasonable period of time since it addressed that letter to them at the property, knowing that they were there, to then file a lawsuit to quiet title.
Now, the wonderful thing about long-term cases like this one is the evidentiary issue. something written in a family Bible, correspondence among family members, planning a time box of what happened that you can pull up. I'm not gone through completely through the record. All these sorts of things that arise that the trial judge yet has to review to determine the ultimate facts or whether it should get to the jury.
That's exactly correct, Your Honor. And I would mention, in addition to the letter, is the simple fact that there's been a house on the property since the 1890s, a very visible house. And that alone, I would argue, raises an issue of fact as to whether it was obvious that they were occupying the property and should have been or was obvious to the state.
How does that put in dispute the $1,510 that was paid to allow the sale to either be legitimized or consummated
Well,
without an appeal from the order allowing the sale?
again, I would say there's an issue of fact as to whether that letter can be characterized in that particular way. The letter, again, on its face, I would argue just says that they're accepting an amount of money for destruction of their improvements. Whether they had knowledge that there was no sale of the property, whether they had knowledge of the greater context of that letter is a disputed issue of fact.
Is there any evidence then that the person who the property was sold to tried to occupy it but got ran off by forebears?
It's a very good question.
We got our $1,500 and I can see someone in an old-fashioned manner saying, move along, this is our family plot, and because it would think that if that happened, he would have gone back to the state and said, not only do you need to pay for the improvements, but you need to run the people out of there so I can have clear title.
Absolutely, and that may have happened, Your Honor, and that is why it's necessary to have a full trial to a jury.
It may have happened. Is there any evidence in the record that did happen?
There's no evidence one way or the other, because, again,
Is there anything that prevented the discovery of that information in order to make that assessment?
yes, Your Honor, the death of the woman to whom the letter was addressed, Miss Belen Sussex.
But is there anything in terms of preventing access to the records that the state has in order to see what happened with respect to that sale, other than what may have happened with the forebear?
In terms of preventing access to the state's records, as much as the state's records are reliable at this point in time, my answer would be no. But in terms of discovering the Sussex's records, or talking to the Sussexes, that's
I understand that, but you still at least have the information that the state had or should have had, and can raise all the necessary inferences from there.
That's correct, Your Honor.
Okay. You had indicated you wanted to save some time, so this may be a good time to do
Any other
that.
questions?
No.
Do you want to just wait for rebuttal?
Okay, that's fair, Your Honor. Thank you.
Okay, thank you.
May it please the court, Your Honors, Messrs. Robinson and Mr. Willenchek. I want to start out by indicating that I'm going to deviate from my original plan to not bore you to death with a detailed recitation of facts, because I think that is well set out in the briefs, and it's obvious that you've all read those briefs and studied the same. To begin with, though, I'd like to clarify one issue that has been play in misdirection from the inception of the defense of this litigation. We saw the defendants begin their brief with a citation from the Hitchhiker's Guide to the Universe. And I'd like to suggest that we're all growing weary of this misnomer that the Adobe home sits on Lot 1E. The Adobe home sits on Lot 1. The same arguments would apply to it, but Lot 1 is owned by the city of Tempe. And Lot 1 and 1E, as part of Section 16, were conveyed to the state for purposes of use by acts of Congress in 1850, 1863, and I believe 1909. Title didn't pass, but the state had the right to use that property for the benefit of the public schools. And what has happened here is a circumstance in which equity, we need to consider, aids those with clean hands. And we don't have a situation where the Sussex family is being deprived of their family home or their ancestral home. We have a situation that from about 1986, 1988, precise date, the land was commercially exploited. And if you believe Exhibits 42, which are leases that were signed by the Sussex family in Cahill, that was to the tune of $494,000 and change at the expense of the children of the state of Arizona.
Counsel, let me ask you the same question I asked
Sure.
your opposing counsel. There's no argument in the opening brief that the trespass judgment was invalid. The only time it gets raised, and all your argument is you're not saying you don't appeal from that. You just appeal from the damage aspect of it. The only first time it's raised is the reply brief, where in a passing half of a sentence it says that the trespass judgment's also invalid. Why isn't that therefore waived? Because it's not in the opening brief. It's not a fair response to your argument about the damages, which is sort of a contingent argument. Why isn't it waived, and why isn't it therefore moot the quiet title appeal?
I think that it is waived, and I think that it is moot, and I think it was waived back in 2005 or 2006 when the motion for summary judgment was filed. Orm School and its progeny on the Celotex trilogy out of the federal courts say you have to, when you have a burden, and the Sussex family had the burden on affirmative defenses, and they didn't plead equitable estoppel, they pled laches. And those are distinguishable legal theories. But needless to say, they had to come forward with competent admissible evidence to support each element of their defense of laches at summary judgment. They didn't do that. And after this court here, the Court of Appeals, remanded the case and struck the Rule 54B language, the whole record was open again, and no motion for reconsideration was ever filed on the issue of title. And essentially what I believe the defendants in their own way are trying to do is not apply the doctrine of equitable estoppel or the doctrine of laches. What they're trying to do is seek adverse possession by somehow precluding the state from asserting its right to title, which is clear from federal legislation as well as the Enabling Act, which is federal, adopted by the state, and the Arizona Constitution. Essentially, Your Honors, the only other point that I'd like to make, and yes, sir.
No,
The only other point that I really wanted to make is that the doctrine of laches, as the court pointed out, has never been applied against the state in Arizona. Equitable estoppel was applied in both Freightways and the Valencia energy cases. And equitable estoppel requires an affirmative act or representation by the state or by a party that is reasonably relied upon to their detriment, and that reliance causes them injury. In this particular case, the state never did anything, and there was no evidence of the use of Lot 1E until aerial photographs that were taken around 1986. The 1979 aerial photograph that was admitted at trial shows nothing or no activity or minimal to no activity on the lot. And we did ask for a quitclaim deed to avoid trespass damages and fees back in 1992, and the Sussex family said no to that. And we would have probably, I also would point out that in 1988, we sold Lot 1E to the city of Tempe for about $21,000, voided the sale because the state ended up in litigation with the Southern Pacific Railway because Lot 1 and arguably a portion of Lot 1E, there's been several replattings, was included in a federal railroad right-of-way. Ultimately, the railway paid the state $1.2 million for the settlement of that suit, and they acquired the Lot 1 where the adobe house sits. And in turn, the railway, after using its small portion of Lot 1, deeded the remaining portion of Lot 1 to the city of Tempe, who now owns the adobe home and the land upon which it sits.
Mr. Katz, on the issue about, and this was your opening remark, that we need to be clear regarding the record. The adobe house is on Lot 1, or was on Lot 1. I don't know if it's still there.
It is still there,
Okay.
yes, ma'am.
But this dispute and this appeal concerns Lot 1E. And here's my question. In looking over the affidavit of Mr. Sussex, he discusses the adobe house, and he talks about outbuildings, fences, and associated facilities. Is the state of the record that all of that is on Lot 1 and not Lot 1E?
There was, I think, a small shack that was half, I don't know the exact proportions, on one lot and the other. But I think that gets back to Judge Kessler's observation that in 1951, I believe it was, the application by Boleyn Sussex to lease Lot 1E was declined. The property was sold at a public auction, with the best notice that the statute requires being given to the world, and there was no bid by the Sussex family for the Ernest Mohammed sale, and no objection, which is allowed by law, to that sale through the Land Department Title 37 statutes. And if the court takes a look at Exhibit 14 from the trial, this isn't the payment. This is a waiver signed by Boleyn Sussex that says, I hereby waive the 30-day appeal period in connection with the amended decisions and orders of the Commissioner dated September 10th, 1956, concerning the proposed sale of the 19-foot of Lot 2, which is now Lot 1E. Lot 2 and 1E are the same, 0.027 acres, and the west 120 of Lot 2, 1.72 acres. The reason that it's divided like that is that the 1930 lease was only for a 19-wide-foot strip of Lot 1E, not the entire lot. So that's why it's broken down. But this was the sale to Ernest Mohammed, the actual reimbursement for improvements, which normally wouldn't have been made because the state doesn't usually reimburse squatters or trespassers. But out of equity and fairness to Boleyn Sussex, they made that $1,500 payment for some temporary improvements that had been torn down by the state on the subject property.
Is there anything within the state records that may have been discovered, I didn't see it, where Mr. Mohammed thought there were still people on the lot he had purchased before he decided, he didn't find to make the payments?
Well, there would have been an appraisal and an inspection of the property before it was auctioned, and there's no notation in the state records that we all could take judicial notice of that there was any belief that there was an illicit use, trespass, or squatting upon the land. And if you go back to the 1938 to 51 or 56 Van Horn and Painter occupancy of that lot and adjacent lots, they certified repetitively in their renewal applications that there were no squatters or trespassers on the subject property. And the state would have acted sooner than it did, but we got embroiled from 1988 to 2002 with the railway litigation.
Counsel, I'm having a little problem pulling up your brief on my
Okay.
computer. I'm just going to ask a quick question. Did you ask for attorney's fees?
In today's proceedings?
For the appeal, yeah.
No, I don't believe we did. What we are asking the court to do, though, in summary, is we're content, even though we think Judge Ray made some serious errors in giving a laches instruction, and laches isn't a jury question, it's an equitable issue that should be decided by the court, but we think that the judge erred in giving a laches instruction and in not following the Constitution Enabling Act by stating that the damages would be the fair rental value in whatever amount the jury would determine was appropriate. However, we're content with the judgment as is, with two exceptions. One, we believe that the awarding of costs on the quiet title action only, and that's what we're seeking, not costs for the trespass or trespass damages, is mandatory and not discretionary. We also believe that we are entitled to the award of our reasonable attorney's fees if the court affirms the judgment on the quiet title action only, which I believe, but I didn't read the affidavit, were an amount of somewhere around $70,000. But in the opposition to our application for attorney's fees, nobody contested the reasonableness of the time invested or the hourly rates that were being charged. The only thing that was set forth in a self-serving hearsay affidavit is that it would be an undue hardship to the Sussex family. But the court never held a hearing on the 4 or 5 factors that you need to consider in balance in the awarding of those fees.
Did anybody ask for an evidentiary hearing on that?
We weren't even given the opportunity for that. We submitted the application, but there wasn't competent evidence to suggest that there would be an undue hardship. At trial, the Sussex family acknowledged that they owned Tempe home, independent of the Adobe home, property up in Crown King, and we had evidence and made the offer of proof that they had a third property. And interestingly, on their other 3 properties, or the 2 that were admitted at trial, they paid taxes. They never made any effort to pay taxes on Lot 1 or Lot 1E. So it's not like they're ignorant of the obligation to pay taxes on land that you claim that you have the right to own or possess.
But you never did ask for an evidentiary hearing on the taxes. On the
Well, we
attorney's
followed
fees.
we followed the rule and presented our application. There was the objection on it on hardship grounds, and the court ended up just ruling. I guess I could have requested rehearing or reconsideration on that issue, but I had felt, or we felt, that the judge had the record in front of him, but he didn't really have any evidence of hardship other than an affidavit saying that this would be a hardship. And I think that there's a requirement for the court, if they're going to balance the factors that the law requires, to have an evidentiary hearing. I don't have anything further, though, unless you have some questions.
Okay, thank you.
Thank you all for your courtesy.
Thank you.
Thank you, Your Honors. Just wanted to address again, Judge Kessler, you asked, your first question was about whether by failure to raise an issue with the ruling, the jury verdict on trespass, we have waived an argument as to...
Actually, it's a summary judgment on trespass. Go ahead, because the jury verdict is different. They got summary judgment on trespass.
Correct.
And did you raise that in your opening brief?
We did not. And the thinking there is that the judge granted summary judgment on trespass based on the earlier ruling on quiet title. Therefore, if the court reverses the ruling on quiet title, the rest of the case becomes moot.
But you didn't argue that in your opening brief.
We did ask for reversal of the quiet title ruling.
Yeah.
Otherwise, just responding to replying to your questions to opposing counsel. I think a lot of the issues with the sale of the property to Ernest Mohammed would have been good issues had this case been brought 50 years ago. I think the thrust of our argument is that due to laches, it's impossible to address those kind of issues. Mr. Muhammad has died. The members of the Sussex family have died. Again, we run across this issue of when a void claim ripens into a valid one. And our argument is that due to that extraordinary delay in time in filing suit, my client's been prejudiced, and therefore...
We're really only talking about, what, 19 feet on 1E?
It is a sliver of land. That's
Okay.
correct, Your Honor.
Okay.
And for what it's worth, the land contains access to the rest of the land and therefore is important. Taxes were mentioned. I would just point out in the record that there's no evidence one way or the other whether or not the Sussexes were paying taxes. And regardless, our argument about prejudice is broader. Oftentimes, taxes are argued as prejudice for laches, the fact that they're paying taxes. Here, there's no evidence one way or the other. So the argument here is rather that prejudice is occurred because, of many other things, of changes in the character of the land, my client's investment in this property as their ancestral home, also inability
The
to
home's
resent
on another lot, isn't it?
part of it.
Couldn't you presented the issue that the family has received tax statements, or at least that they are in the county office, to show that, regardless of whether they were paid, that there are people who thought that the Sussex owned the property and should have been paying taxes?
And again, whether or not they were is not even a part of the record. So I would just point that out because my client does have, there is a broader story to that, which is nowhere in the record. So our position is that the taxes issue is, cannot be addressed here. It's not part of the record, but we have presented enough to show that there's a dispute issue fact as to laches, and therefore the case can proceed to trial by jury.
Thank you, counsel. Thank both counsel for their arguments. We'll take this matter under advisement and issue a written decision in due course. With that, we stand adjourned.